So with housekeeping, sorry. So with housekeeping out of the way, we'll go ahead and dive into today's session. We have legal aid staff attorney Josh Jackson with us today. Josh is an attorney licensed in Arkansas, Texas, and Tennessee, practicing primarily in family and probate related matters, including contested guardianships, adoptions, and related civil litigation. He holds a JD MBA from the University of Arkansas and a BA in French from Harding University. He regularly works at the intersection of statutory guardianship law, procedural compliance, and practical courtroom strategy. His practice frequently involves navigating contested and capacity issues and fiduciary disputes. Please join me in welcoming Josh Jackson.
Well, good afternoon, everyone. Let me share my screen so I can get presentation pulled up here. All right. So this presentation is going to be about the legal standards, procedures, and hopefully some practical insights that can be useful um, in real cases. Um, so guardianship's one of the most powerful remedies a court can impose, and it directly affects, you know, personal liberty, a person's autonomy, and even property rights. Um, so that's life, liberty, and property right there. So, um, because of this impact, um, the law treats guardianships with special care, and there's a lot of boxes that need to be checked that sometimes get glossed over. Um, and to, so the goal today is basically to clarify the statutory requirements, explain how courts generally apply them, and identify uh, common pitfalls. So again, I want to thank Haling and Casey for all the work they put in behind the scenes to make this presentation possible. Um, they'll have a spiel afterwards, and they do a great job as heading up our pro bono team. And hopefully, some of you will volunteer with us. We usually, try to make life easy for our pro bono volunteers. But anyway, this is kind of the roadmap of what we're going to discuss today. Um, Basically, we want to talk about the purpose, scope, and types of guardianships, the evidentiary requirements, um, duties and responsibilities of guardians, rights of the ward, and several other things as well. Um, Basically, there's several different types of guardianships. There's emergency guardianships, which we'll get into. Sometimes guardianships can be contested, um, and then there's mental health related incapacities, and guardianship work intersects with probate, family law, constitutional law, and public benefits. So there's a lot of overlapping and a lot of moving parts that sometimes come into play. Um, so these are generally the statutes that you're going to deal with in this work. Um, Basically, ACA 2865-101 through 707 deals with guardianships. And then, of course, there's jurisdiction. And a common pitfall that I've noticed is that sometimes people will file guardianships where the guardian is domiciled instead of um, where the ward is domiciled, um, and that's a common uh, problem that sometimes arises. It's supposed to be where the ward is domiciled. There are exceptions to that, but that's the general rule, and it can cause problems if you don't do it correctly. Um, so um, here's some general definitions. I'm not going to read all of them, but just to point out on the emergency guardianships, this is a new change that's happened, within the last year, I believe, where in which it can be in effect for no more than 14 continuous calendar days. I believe it used to be 20. Um, and weekends and holidays do count. So, we had trouble getting an emergency hearing scheduled when it was 20 days. We'll see how it works out with 14. Um, they didn't ask for my input on that, and they probably should have. um, so there are other requirements as well, in that the guardian has, to make sure that things like healthcare, food, and shelter are all provided for. Um, an evaluation, that's a professional assessment, and we'll get into that. It's only for adult guardianships. Um, and the guardian is the person appointed, and the guardian ad litem, a person appointed by the court in a particular proceeding to represent the ward. And it's important that guardianships are, a lot of times we might think of them as a single order at the end of um, a case, and that's not really um, the way we should think about them. The way we should think about them is that order is just the beginning, because there's going to be continuous requirements for um, reporting, accounting, um, and the court may order review hearings, and it's best if the client knows beforehand that there's going to be additional responsibilities after the guardianship is granted, and the case will remain open as long as the guardianship is in place. Um, this section also defines an incapacitated person. Um, so it's basically a person impaired by reason of a disability, such as a mental illness, mental deficiency, physical illness, chronic use of drugs, or chronic intoxication. Um, I have never seen, though, if you have seen this, let me know about it, because I would like to know about it. I've never seen chronic use of drugs or chronic intoxication be the reason that a guardianship is granted, though obviously it's theoretically possible. In any case, there's additionally a medical, or excuse me, a religious carve out. Um, in section C, the legislature wanted to make it clear that refusing medical treatment and only relying on prayer in accordance with a person's religious tradition um, is not a reason that a person can be deemed incapacitated. There have to be other factors other than that. That's not enough. Additionally, we want to find the least restrictive alternative. Um, if there's another way of achieving what the guardian is trying to achieve, then that's the way the law requires the court to go. Um, Additionally, the court can limit the powers of a guardian um, to only specific powers, and those have to be outlined. And then it defines the definition of relative and temporary guardian. Temporary guardianships only last for 90 days, but the court can extend that, obviously. And then the ward is the incapacitated over um, that the guardian is taken care of. Um, so here's the full statute on the definition of incapacitated persons. This is pretty important because, um, you know, there has to be a ruling in the hearing that the person is incapacitated. So it's persons under the age of 18, and um, the guardianship will continue until the age of 21, unless the ward has reached the age of 18 and then challenges it. Um, Having a current guardianship established based solely on minority of uh, of age, and then they can challenge it and potentially get that removed, but it automatically ends at 21. So um, these are more definitions. I mean, there's a lot of reasons why a person can be deemed incapacitated. Um, so it can be you just have basically the standard is you can't adequately manage personal or financial affairs. And it lists the reasons, and there's also a catch-all for other similar causes. Um, you know, there's several different reasons why, but and like I said earlier, I've never seen um, chronic use of alcohol or drugs as a reason, but I would love to hear about a case where that happened if you have it. Um, so this is about the emergency and temporary guardianships. Those are two separate things. It's important to keep that in mind. Um, Emergency guardianships only last for 14 days. Um, there has to be um, a motion and affidavit. If the motion is verified, you can dispense with the affidavit, but there has to at least be a motion. But I would recommend the affidavit for sure. Limitation is 14 days. Standard of proof is clear and convincing. I was telling somebody the other day, I don't think any lawyer can tell you what clear and convincing means. It just means more than the preponderance of evidence and less than beyond all reasonable doubt. So it's different from person to person. If you could find a definition of clear and convincing evidence that uh, everyone agreed to, you could probably make a lot of money doing guardianships. Um, and then there's consequences for failure to give notice to the proper people. And then, of course, letters have to be issued by the clerk after the order is entered. Um, the law also allows for the nomination of a guardian. Um, there's a lot of caveats to this. Number one is that the court is not bound by the nomination of a person. So if parent A uh, nominates person X to be the guardian, and parent B is still living, then the court will prefer um, to place the child with the um, surviving legal parent. And then, uh, if that's an unacceptable alternative, then the nominee will be considered. And even in that case, the court is not bound to do though um, it should be given extra weight because that's the wishes of the parent, and that's what the law also requires. Um, so, like I said, a deceased parent's nomination can't override the legal rights of the surviving parent. In this case, this is for establishing the preference the court should follow when appointing a guardian. Obviously, I'm not going to read all the entire statute to you, but um, the court can consider um, advance directives and written requests, a minor's preference if they're over the age of 14. So below the age of 14, we don't really care what they prefer. after the age of 14, it can be given some weight, although that's not, none of these are um, a silver bullet. None of these trump, um, none of these automatically mean that you're automatically going to get what you want. You can also take into account the spouse's recommendation for adult guardianships, and then there's a preference for relatives that are related by either blood or by marriage. Um, there are several layers, so the closer you are related to the ward, the more likely it is you'll be granted guardianship. Although someone who's not related at all can still be guardian. Um, these are the things that have to be addressed in the petition for guardianship. Um, you know, you have to state the identity of the person and the nature of their incapacity. Those are the two most important things. Um, who's going to be the custodian or caregiver? Are there existing guardians? Um, recommendation on guardianship, and there has to be a statement that there are no other um, less restrictive alternatives as well. So all of these things really need to be in the petition when you file, and needs to clearly state that there's uh, a reason for the guardianship and the nature of the incapacity as well. Um, so I've seen a lot of, especially adult guardianships, where it's just a bare bones petition and they don't um, allege everything they need to allege. Sometimes that's overlooked. Sometimes it's not. So um, just know that this is an important. These are important things to include, and you don't. It's best not to leave any one of these out. Um, so there's also notice requirements about who has to be notified and when they have to be notified. So obviously, the alleged incapacitated person has to be notified. The parents of that person, if they're a minor, um, the spouse in the case of an adult guardianship, and any existing guardian if you're trying to get substitution or termination, and then any if there's no known parent or spouse, at least one nearest competent relative, and then of course there's a catch-all that the court can direct the petitioner to give notice to um, whoever the court deems is necessary as well. Um, so um, this is who does not need notice. Obviously, anyone who signed the petition doesn't need notice. Um, anyone who waived notice in writing, and this is an important point. The alleged incapacitated person cannot waive their own notice. You can't say on one hand that a person is incapacitated in the petition and then say that they're competent to sign a waiver. Those are two contradictory things. And I would argue that, you know, that would not be valid. It would not be a valid waiver if they did that. Additionally, anyone who actually appears at the hearing doesn't need notice. Anyone whose existence, relationship, or whereabouts are unknown after your due diligence. Anyone other than the alleged incapacitated person whom the court finds is outside the continental U.S. So if they're outside the country, you don't have to give them notice. And not just for a vacation. It's got to be they're residing outside the country for an extended period of time. And the alleged incapacitated person only if the court finds they're detained by a foreign power. So if they're in prison in North Korea, you don't have to give them notice. And these are the people who have to receive notice under ACA 2865-208 of other hearings. So subsequent hearings, the temporary hearing or the final hearing, the guardian of the person, guardian of the estates, and if the court directs it, departments, and any other person the court designates. An important thing to note here is that if someone is the guardian of less than 5 people already, they don't have to um, give notice to DHS. But if they're guardian to 5 or more people already and they're trying to get guardianship over another person, then they do have to, I think for obvious reasons. You don't want to have people getting guardianship over that many kids if they can't take care of them. So, additionally, there are agencies that can request notice. Also, any other interested person. There's and this is after guardianship letters of guardianship have been issued. Subsequent hearings can be of interest to certain agencies or people involved in the case. So, so to qualify as a ward, the individual for whom guardianship is being sought must be confirmed as either a minor or an incapacitated person. And as I said before, that means inability to care for essential health or safety or manage the estate due to the disability. So if you can't take care of yourself, you're potentially a ward. And the court must find that guardianship is desirable to protect the ward's interest, and there are no other less restrictive alternatives. Additionally, the nominated person, as I mentioned before, has to meet all the qualifications too. You can't just get a loophole by nomination. They have to be over the age of 18 and meet all the other requirements. So these are the things that can potentially be viewed as evidence of incapacity. So there can be testimony about minority or disappearance or detention by a foreign power. All of those things have to be shown by satisfactory evidence. Professional evidence, this is almost always relevant in adult guardianships. It can be either oral testimony of a professional or sworn statements. I usually just have their doctor fill out an affidavit and file it with the petition. You can theoretically get a medical professional to come to court. Good luck with that. I don't think that I've never seen that happen, and it's just easier to do it on the front end with physician's affidavit. If the individual is in a hospital, there must be one evaluator must be from the medical staff of that facility, and the court may require can also take its own observation of the ward, and then costs are sometimes incurred, and the court can set fees for the examiners if need be. So, evaluations. Uh, the evaluation must be done by professionals with appropriate expertise related to the alleged incapacity. Doesn't necessarily have to be a medical doctor. Um, even in one of my cases, I even had a nurse practitioner, um, and the court had zero issues with that. As long as it's a they're legitimate medical professional. I think that there's a good chance that the court will not have any issues with that. Um, Now, if you present an affidavit from a witch doctor or something, I don't think that that's going to fly. But um, you know, there's a wide latitude for who can perform that. The court can order independent evaluations, even uh, especially if there's been no recent evaluation, and recent being within the last 6 months. Uh, and the evaluation has to include all of these things: a physical condition, adaptive behavior, and intellectual functioning. And it also has to include the professional's recommendation about whether a guardianship is necessary in this particular case. Um, a professional evaluation has to be done before the hearing. Um, there are exceptions to that, and we can get into that if we want to. It's rare, but it happens. Um, and then as I mentioned before, there are cases where you have to notify DHS, um, and generally DHS can't um, provide any evaluations unless the parties are indigent and the services are within the state of Arkansas. So, the Ward's Bill of Rights and due process. This is another thing that's changed recently. Um, in adult guardianship cases, you have to serve the ward with a Bill of Rights, um, and a copy of the statute as well. Um, Basically, the ward, it just makes sure that the ward keeps all legal and civil rights, um, except for the ones limited by the court order. That there's a right to appropriate communication and visitation, right to participate in decisions affecting their life, including preferences about treatment, and a right to receive notice of rights, pleadings, and notices of hearings. Uh, and then, like I said, a copy has to be served on the ward. This can be, and there are some cases where it's obvious that the person being served is not going to understand what they're being served with. I still think it's an important box to check, because at the end of the day, you're taking someone's rights from them, and there has to be um, some due process, so that they uh, those rights aren't just taken um, without regard to you know the ward's uh, wishes um, or rights. So, um, as far as due process, um, this is the order of preference this is for minor guardianships. Um, Generally, parents are preferred. Uh, Blood or marriage relationship to the person is next, and then other people, and then they can, you know, take into account the written request and the request by the spouse of an incapacitated person. Um, so from there, let's talk about the rights that this statute specifically addresses. Um, so these are the broad categories of things that the due process statute uh, encompasses. So there's the rights at the hearing. You have the right to present evidence, cross-examine the witnesses, including the expert witness, um, which can present problems if the adult guardianship is contested. Um, so just know that. Um, Additionally, they're entitled to require the attendance of non-parties by a subpoena. They have the right to be represented by an attorney, and it informs them of the burden of proof, and that they have the right to present alternatives to the guardianship, um, as well as be present at the hearing. So this is sort of the order of things at the once the guardianship order is entered. There's the bond of the guardian. You could also put here the acceptance if the bond is waived. If the ward doesn't have property, the court can waive bond. And once that is taken care of, then the clerk will issue letters of guardianship, and then there are certain forms. There's a form of the letters have to take. There has to say certain things. So the court order, let's start with that. Court order establishing guardianship shall contain the following things. That the ward is incapacitated and in need of a guardian of the person, estate, or both. And if the court is satisfied that a guardian should be appointed, then the court shall appoint one or two general or limited guardians of the person or estate, or both. So there can be a guardian of the person and a separate guardian of the estate. Doesn't necessarily have to be the same person. However, to be co-guardian, generally you have to be married. Additionally, the order will specify, the nature of the guardianship, and if there's going to be a bond. If the court determines the guardians should be limited, then it has to delineate exactly in what ways the guardians will be limited in the power and the scope of their guardianship. And then they have to take into account the right of the incapacitated person to rely on non-medical remedial treatment in accordance with a recognized religious method of healing in lieu of medical care. Like I mentioned before, simply the refusal of medical treatment and reliance solely on prayer is not enough. You have to prove, you have to show evidence that they're incapacitated beyond that. And then the order may take into account provisions for visitation and child support, just like any other custody case if it's a minor guardianship. Okay, so once that's taken care of, the letters have to be issued, and they have to delineate they have to say whether the guardian of the person or the estate. And if it's a limited guardianship, then the court has to, the letters have to say exactly in what ways the guardianship is limited. So basically, this part of the statute says that the letters can be relied upon and protect persons who in good faith act in reliance on them. So basically, there's, like I said before, the letters have to delineate the powers, the authorities, and the duties of the guardian. And if they're limited, they have to state how limited they are. and state specifically what they are entitled to do and what they're not entitled to do. Um, so here are the qualifications that have to be met for guardians. Um, all of these are pretty standard. I think most people are aware of them. Um, but the one I want to draw attention to is they're not a convicted or unpardoned felon. That's something that's changed um, even since I've been practicing law, and uh, the law does allow convicted and unpardoned felons to become guardians. But you have to make the court aware of it. You have to present the court with a certified copy of the sentencing order, and the court has to approve it. Now, I have had I had a client once who had committed and convicted of a uh, Y class felony, and I'm talking to a group of people that knows what a Y class felony is, and she still got uh, guardianship over her grandson. So that's not uh, dispositive. You just because you're a convicted felon does not necessarily mean um, that you're not going to be able to get guardianship over the proposed ward. Um, so uh, moving on, um, guardians are allowed. I've found that it's kind of uncommon, but guardians are allowed to be compensated, um, and attorneys' fees and costs are allowed to be collected in certain circumstances. And of course, there are requirements for bond if there's a claim on the estate of the proposed ward from another person or entity. Um, so, in terms of the compensation of a guardian shall be allowed such compensation for his or her services as guardian as the court shall deem just and reasonable. So there's a lot of latitude in that language. If the court finds that the guardian has failed to discharge his or her duties as such in any respect, it may deny him or her any compensation. So um, it's not like that's the nature of guardianships. They're not without oversight, and if the court thinks that the guardian is not living up to their responsibilities, then it can rescind um, compensation as well as give it. So basically, attorney fees and costs. It's a pretty standard. These are pretty standard reasons for why you would get fees and costs in any other case. It's usually when a party is acting in bad faith or uh, they're you know found in contempt or anything like that. You can't just get the attorney's fees for getting a guardianship if none of these conditions are met. So there's only specific times when you can get those covered. And then the bond of the guardian. Um, this is the statute that describes the procedures um, with respect to the bonds of uh, personal representatives, but they're also applicable to uh, guardians as well. So, um, any action by a ward against his or her guardian for a settlement, the actions can be initiated by the ward in certain situations. So, for example, substitution or removal. If a minor is over the age of 14, he or she can petition the court to remove the guardian or substitute the guardian, and the guardian can be removed. So that's a potential um, caveat there. Additionally, so here are basically the powers and duties of a guardian of the person. Um, Basically, there's obviously the care and maintenance of the ward, the custody of the ward, um, the reporting to the court, and then there has to be um, account taken for the religious or medical considerations uh, that the court thinks is necessary. So, uh, a lot of things that have to be done uh, for that. The reporting has to be um, done on an annual basis, as I'm sure most of you are aware, um, and that's just the report. The accounting is for the estate, uh, and these are the powers and duties of the guardians of the estate. You have to possess and manage the ward's property, uh, protect and preserve the estate, and you have a fiduciary relationship akin to um, that of a trustee for a trust. Um, and you have a responsibility to um, manage funds in a responsible way as well. So there are limitations and principles uh, over guardianships. Court can limit it um, to basically can limit a guardianship and protect the well-being of the ward and their property. It's just the courts are given a lot of latitude in this area. So if the court deems it necessary, they can limit the scope. Um, the court is always going to have continuing oversight over the guardian, um, and like I said before, there's the application of trust law. Um, it's it's guided by the duties and liabilities of a guardian of an estate are guided by the principles of trust law. And there's a case directly on point on that. And then termination. A guardianship can terminate for several reasons, either by the death of the ward or the court can deem that a guardianship is no longer necessary. Um, the ward is no longer incapacitated. Um, it ends for if the incapacity was for reason of the ward's minority, it ends automatically at 21, but it can be terminated at 18 if the ward requests that it be terminated, or if the guardian requests that it be terminated. So they last till the way I like to think about it is they last until 18 with an option for 3 more. Um, so, but they end automatically at 21. So, um, additionally, the guardianship was solely because of the minority. Like I said, you can age out of a guardianship, and the court can find by clear and convincing evidence after a hearing that it's in the ward's best interest to continue after the ward reaches majority. Uh, and the provisions in the Ward's Bill of Rights will always always govern. Um, and then finally, if it's no longer necessary or it's in the best interest of the ward, then the guardianship will terminate as well. So foreign guardians, you may remember on a previous slide, it said that there's one of the requirements was that they be a resident of Arkansas. That's generally true, but it is possible, theoretically, for residents of a different state to be granted guardianship. They have to be, first of all, they have to be granted permission, basically granted permission to act in Arkansas. It allows people in other states to do that. You do have to set up a registered agent for service. Um, and um, the statute applies to foreign guardians defined as guardians, curators, conservators, committees, tutors, or other persons authorized by law of another jurisdiction to have possession and control of an incompetent person's property. So that's something that we need to be mindful of. Um, can also be denied. Um, you know, like I said, the court is given a great deal of discretion here. Um, there can also be corporate guardians. It's rare, but it happens. Um, they don't need to qualify. They don't have to register to do business in Arkansas to be the guardian, but it is possible. They, like every other guardian, they just need court permission. And then if the foreign guardian is a corporation, it doesn't need to qualify. Like I said, doesn't need to qualify to do business under the general corporation laws of Arkansas. Um, and then there are times when a public agency can be a guardian of particularly people who are over the age of majority and are incapacitated by, whether it be dementia or mental illness or whatever. If they don't have any relatives, then sometimes the um, a government agency can step in and be guardian. Additionally, there's certain things. This was important to be mindful of. Certain requirements that if there's a disabled veteran who's a ward in a guardianship case, there are certain requirements that have to be met, um, and to take care of those benefits. And so just be mindful of that. Um, additionally, um, there's a provision for conservators for the aged and disabled. Uh, so basically, um, it allows a responsible person to manage the estate or financial affairs of an aged or disabled person, um, but it's not necessarily when a person is declared incapacitated, um, and they usually have to consent to that. And then if there's ever a dispute about um, which state has jurisdiction, that can arise sometimes. But there's a law called the Uniform Adult Guardianship and Protected Proceedings Jurisdiction Act, and it establishes which state has authority. It's just something that's important to be mindful of. We don't have to go through all the provisions of it, but that's something that has to be taken into account there. All right, so that concludes my portion of it, of the presentation. Thank you for your attention. I'm going to turn it over to Haling and Casey now to talk about potential pro bono service opportunities.
Thank you, Josh, for such an insightful presentation today and for just taking the time to share your expertise with us. And like you said, we'll go ahead and move forward with our pro bono director, Casey Copeland, who's going to step in and talk to us a little bit about pro bono service and ways that you can become involved.
Hey everyone, thanks a lot for joining us today. I hope this was informative and helpful to you. One of the things we're trying to do at Legal Aid is to provide more services to our legal partners, our pro bono volunteers, our community partners through education programs like this. So be on the lookout for more to come later this year. We're going to do some on estate planning, maybe some on landlord tenant stuff, and a variety of other topics. And if there's a topic you would like us to discuss, please feel free to shoot me an email and let me know that you'd like to learn little bit more about whether it's bankruptcies or food stamps cases or education, whatever it is. We'll try to accommodate those requests. But the main mission of Legal Aid of Arkansas, of course, is to help spread civil legal assistance to low-income Arkansans through our pro bono program, which includes both some free legal clinics that we do from time to time and direct referrals of pro bono cases. So if you've got room on your caseload to take a pro bono case every once in a while, let us know. Make sure you're on our list. We've got a lot of resources to help our volunteers, from templates and forms to really good attorneys like Josh Jackson that you can call and ask questions or act as co-counsel or whatever it may be. We're here to help you help Arkansans that we serve. Our website is out there. There's a link here on this screen for you to go and sign up to be a volunteer, or you can just email or give me a call. Again, we really appreciate you joining us today. Does anybody have any questions about either the material or legal aid or anything you'd like us to address before we shut this down? If not, I want to try a couple. I had some. Where'd they go? Well, I had some polls ready to go, but I can't find them now. So, oh, there they are. Let's try a poll here. So this poll just asked, how many of you have represented proposed guardians before? Coming in, looks like most of you have, about 70% to 30%, or roughly thereabouts. All right. We got one more poll. Let's share those. And then how many of you have represented proposed wards before? This is not something a lot of attorneys end up doing, but I've done it a few times, and maybe some of you have as well. No. Yeah, they look like very many. Vast majority of you did not or have not represented proposed wards. Again, that's kind of a unique situation to be in unless you're doing, some sort of work as a public defender with APS cases, things like that. So, again, want to just thank you all for joining us. I'll try to get the CLE forms out today. If you don't get one from me by the end of today, just shoot me an email and I'll get that to you, and then we'll get all that turned in for you. So, unless there are any questions, we really thank you for being here, and hopefully we'll see you again the next time.
Thank you all so much. There is one question that someone just dropped in the chat. I'll go ahead and mention that. The question is, I may have been confused when you referred to incapacitated waiving notice or executing consent when already deemed incapacitated. Can you explain how we go about that? And also, serving 14 and over, do they sign consent? If so, how, if a minor?
So for if it's an adult guardianship and you're trying to say that they're incapacitated for whatever reason, whatever intellectual disability or dementia or whatever, then you can't, on the one hand, be alleging in your petition that they're incapacitated and then allow them to waive service by just signing a piece of paper, because they have to have capacity to do that. So you can't say they have incapacity on one hand and then capacity on the other. You have to be consistent about that. So I've never seen it challenged on that basis, but I would argue that if someone who you're alleging is incapacitated signs a waiver, then you're you haven't, either they're not incapacitated, which means you won't get the guardianship, or that's not a valid waiver. What was the other part of the question?
The other part of the question was on executing consent when already deemed incapacitated. Can
Oh,
you explain how we go about that? And
it
also
doesn't.
serving 14 and over, how do they sign consent if a minor?
So there's no requirement for the 14-year-old to have to sign the consent. I usually just have them come to court, and um, you know, normally they don't have any objection to the guardian, but the court can just take that into account. It's not something that's going to be determinative of the outcome. And generally, if someone's already been considered incapacitated, then by definition, you can't get them to sign a waiver. Um, uh, so that's hopefully that answers the question. If not, let me know.
Okay, so they come to the hearing on notice, and then you and the judge may inquire of incapacitated.
For the 14-year-old, the people who are 14 or older, if they're under the age of 18, they're incapacitated, and the court can take the opinion of a 14 to 18-year-old into account. That doesn't mean that the court is bound by what that minor wants, but that can be taken into account.
This would be actually for the adult. They just clarified.
Oh, for the adult, you still should have them appear in court if you can, and if not, then you have to have permission from the courts not to have them there. The court can inquire as to their preferences too, but again, the court's not bound by that. And I'll be quick to add that I usually like to when I serve the ward, because you're serving them with the petition, the summons, and the ward's Bill of Rights, and potentially I like to include the notice of hearing already, especially if it's already been scheduled. And yeah, that's everything. Is there another question?
No, we don't have any further questions at this time. Feel free to email us if you guys do have any. And yes, I just want to clarify that yes, you will be provided with a copy of today's presentation materials, along with a few other forms like an evaluation form, certificate of attendance, that kind of thing. Also probably a brief internal survey, just get your feedback on how we did today. And with that, if we have no further questions, that concludes today's program. We thank you all so much for taking the time to be with us this afternoon. We encourage you to stay connected with us on behalf of our team. Again, thank you for joining us, and you guys have a great weekend and afternoon.
Thank y'all.